And you're making these decisions based on a law that was in place at that time, and now being told 4, 6, 8, 10 years later, well, actually, no, that was a misapplication of the law, and we're rewriting it.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
Today, I'm joined by Friedman Vartolo, Senior Trial Counsel, Henry DiStefano, and we're going to be going over some of the top litigation risks that lenders and servicers are currently facing in New York. Henry, how's it going?
Good, very good.
A lot of the calls I get from clients obviously centers around New York. It's one of the riskier litigation-heavy states in the country. So to jump in, what's a big issue that our clients are facing in New York right now?
Biggest issue in New York, which has lasted now for almost 3 years, is FAPA and its applications to New York foreclosure actions. It's an issue that is in constant litigation and constant growth and development. The trial courts gave us one impression mostly with regards to its applicability, and it seemed to be more creditor friendly. But subsequent to that, the appellate divisions have not been as friendly. The retroactivity is the most significant issue in relation to FAPA, and it has tentacles because the retroactivity affects things like standing, affects things like statute of limitations, which really are the other significant issues that are out there today that we're trying to tackle.
When we look at FAPA from a practical perspective, specifically the retroactivity, and we think about, how can a servicer or lender minimize their exposure or their risk, it's really about not buying loans that are problematic, right? Like once you own a loan that has an issue created by the retroactivity part of FAPA, you kind of are where you are, right? Like there's nothing you could do to guard against that in the middle of a case. Right?
Absolutely. That would be the safest approach and the best recommendation to offer our clients, because with something like FAPA, well, before FAPA, in most instances, if new legislation came down, it was being applied and going into effect the date that it was actually signed or a date sometime thereafter, 30 days, 90 days, 6 months, whatever the scenario is. FAPA is taking us to another level. FAPA is now indicating that this is the law and it always has been the law. And you may not have realized that back in the past, but it is now. And it opens up the gates to many attacks on many issues that everyone thought was either easily resolved or perhaps decisions made based on very strategic thought on how to handle an older case and wanting to preserve your right to continue to litigate. And you're making these decisions based on a law that was in place at that time, and now being told 4, 6, 8, 10 years later, well, actually, no, that was a misapplication of the law, and we're rewriting it. Puts you in a horrible position.
What other big issues are there?
The FAPA issue really branches out into things like standing and, again, the statute of limitations. New York State, you have a statute of limitations of 6 years. Doesn't mean you have to finish your action in 6 years. It just means once the loan is accelerated, you need to have this case advanced within that 6-year period. This, again, dovetails with so much of the history of foreclosures. A case like Engel, which came down and stated that a voluntary discontinuance is essentially a rescission of the prior acceleration, is significant because it gives you a new statute of limitations time period to work with. Well, under FAPA, it's not so easy to simply voluntarily discontinue. The language that's been utilized is that you need to demonstrate an express judicial determination that was made upon a timely imposed defense that the mortgage was not validly accelerated.
To deaccelerate a loan properly, what do I have to do?
That's a tough question under FAPA, actually. So pre-FAPA, what was generally recognized was that you could deaccelerate potentially by a letter with very clear express terms, or there was case law about 100 years old that allowed you to deaccelerate pursuant to the filing of a voluntary discontinuance. Now, there's some debate on that. Clearly, some borrowers' counsels will disagree, but the case law is there, it is substantive, and it did allow for that. The decision by the Court of Appeals on Engel in December of 2022 pretty much cemented and reinforced it and put creditors in a much more comfortable position. If they had a case where they realized there was an issue with acceleration, particularly if it related to standing, you could voluntarily discontinue the case and have an opportunity to recommence. There were some limitations with regards to how much you could go back and seek on a recovery for a default amount if it exceeded 6 years. And I suppose that would be the penalty in order to recommence. But at least it gave you the opportunity to pursue relief. FAPA now has unwound that. And based on the best interpretation, we're going to go back to that same language I referenced before, that there needs to be expressed judicial determination made upon a timely imposed offense that the mortgage is not validly accelerated, which in plain language would be an actual decision from the court clearly indicating that the plaintiff lacked standing and said result was on the basis of a defense that was raised. A voluntary discontinuance is being treated as a unilateral act. Unilateral acts of the accelerate alone in order to preserve a statute of limitation are frowned upon and now prohibited. And therefore, if you don't have a judicial determination on the specific issue, you really can't deaccelerate.
If you file a motion to discontinue, is that sufficient?
A motion alone, arguably speaking, may not be sufficient depending on how strictly this is applied. And I think this is part of the challenge because the appellate division has applied the statute in a manner which I believe has been much more front-facing. The statute indicates ABC, this is how we're applying the statute. Whereas I believe the trial court has actually applied some more assessment of the law and its applications and its equitable applications with regards to a case that's being litigated over the course of, again, anywhere from 5 to 15 years with foreclosure actions. So a motion to discontinue alone, while plaintiff would argue would suffice, I could see a defense counsel arguing if they don't oppose it and they don't raise a defense and the motion is granted, they would think that they would have the opportunity to refute our claims that there is an actual determination made. I would argue the latter.
What if defense counsel opposed it?
If defense counsel opposed it, I believe that it significantly increases the plaintiff's argument to be able to say, assuming that the case is discontinued, that a defense was alleged and therefore it was fairly litigated. The opportunity was given to the defense to take its position and the court made a judicial determination.
The lack of response or lack of opposition when given the opportunity, I feel like the opportunity is the key. If given the opportunity to respond, where obviously in a voluntary discontinuance, there's no opportunity to respond. That's clear, it's a unilateral decision. But when a motion is filed, there's a presumption that if you don't respond, it's because you didn't have a good response.
And I believe that's the normal, rational, fairly consistently recognized approach and assessment of that. The concern, and perhaps I'm more on the conservative side, more of the alarmist side, but the way FAPA is written and the way it's being applied gives me pause for even the most simple or most commonly recognized approaches that have been used for years and years and years. And now you have to stop and wonder. Perhaps I'm mistaken. I hope to be mistaken because it's just going to make it a lot harder for all of us.
This is very interesting stuff. I think you're doing a good job of bringing out the practical way these issues have to be approached, which I think is very helpful for our clients. Thank you for joining Henry DiStefano and I in the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.